ओके, सो वी आर लाइव नाउ। ऑडियंस भी हमें देख पाती होगी। स्टार्ट।
Sir, shall we start? Hello.
Am I audible?
Yes, 87.
Yeah. Yes.
87 participants are there. You can start.
Yeah. So start कर देते हैं सर, प्लीज। बख्शी सर, बख्शी सर इज ऑन। हेलो बख्शी सर।
Yeah, am I audible?
Yeah,
Yes, sir.
Yes, sir.
Start, sir, please.
Yeah. So, shall we start, sir? If you permit me, then we will start.
Yeah, please start, sir.
Yeah, okay, sir. Thank you very much, sir. Good afternoon, everybody. आज SHRP और से एक और अच्छा सा प्रोग्राम हम प्रेजेंट करने जा रहे हैं, वेज कोड एंड इंडस्ट्रियल कोड के ऊपर। सबसे पहले मैं थोड़ा सा SHRP का बैकग्राउंड दे देता हूँ। SHRP is founded in 2018 by two young HR professional, निशांत पंड्या एंड आशीष सोनी। एक्चुअली मोटो वो था कि जो डिप्राइव लोग हैं, जो पासिंग करते हैं कॉलेज से, बाद में इंस्टीट्यूट से, फिर इंडस्ट्रीज और जो इंस्टीट्यूट और इंडस्ट्रीज के बीच में जो गैप है, इट इज वेरी वाइड गैप। तो वो कैसे फुलफिल की जाए, उसके लिए दे हैव स्टार्टेड कि चलो हम लोग कुछ मिलकर कुछ करते हैं। एंड उनके जो एफर्ट्स थी उसमें से SHRP का ये जन्म हुआ सर। जब छुआ तब तो हम लोग 15-20 लोग ही मिलते थे। देन अभी ऐसा है कि 2 साल हो गए हमारे SHRP को, आज कंप्लीट अक्टूबर में, लास्ट अक्टूबर में हमने 2 साल कंप्लीट कर लिया है। अभी वी हैव 1500 मेंबर्स सर। तो SHRP एक्चुअली वेरी फास्टली ग्रोइंग इन HR फील्ड। 2 साल में हम लोगों ने काफी प्रोग्राम्स किए, उसमें रीजनल फैकल्टीज भी थी, नेशनल फैकल्टीज भी इनवाइट किया है और इंटरनेशनल फैकल्टीज भी हमने इनवाइट की है। ऐसा है, मतलब कि वी आर ट्राइंग टू गिव इट आवर बेस्ट टू ऑल, सबको कुछ अच्छा सा मिले। और ज्यादातर हमारी जो है उसमें यंग प्रोफेशनल बहुत ज्यादा है। तो यंग प्रोफेशनल को क्या है कि हम लोग सोचते हैं कि दे गेट एवरीथिंग, जो उनको जरूरत है इस हिसाब से सब कुछ मिले। ऐसा एक प्लेटफॉर्म हम SHRP के थ्रू उनको देने की कोशिश कर रहे हैं। अभी SHRP में बहुत पॉपुलर भी हो गया है, काफी लोग को हमारे प्रोग्राम्स उन लोगों को पसंद आते हैं, क्योंकि जो नॉलेज शेयरिंग हमारा जो मोटो होता है कि ज्यादातर सिलेक्टिव ही प्रोग्राम हम लोग करते हैं और उसमें हम लोग सोचते हैं कि अच्छे से अच्छा सबको नॉलेज मिले। दैट इज आवर मेन ऑब्जेक्टिव। तो उसके हिसाब से हमारा सब प्रोग्राम अच्छे चल रहे हैं। काफी प्रोग्राम हुए, बहुत अच्छी फैकल्टियों ने प्रोग्राम दिए। आज भी ऐसा ही था कुछ अच्छा सा करें हम लोग। तो इसलिए आज हम लोगों ने अतुल भाई से, मैं थोड़े बहुत दिन से टच में था कि सर कोई अच्छी सी फैकल्टी लाइए, कोई अच्छी सी फैकल्टी लाइए, क्योंकि फैकल्टी तो होता है लेकिन जो लोगों को चाहिए वो दे सके वो ही हम लोग प्रिफर करते हैं। तो अतुल भाई ने बख्शी साहब का नाम सजेस्ट किया, तो मैंने कहा बख्शी साहब का तो कोई विकल्प ही नहीं है दूसरा गुजरात में क्योंकि उनका नॉलेज के बारे में कुछ बताने की जरूरत ही नहीं है। आई वुड लाइक टू थैंक्स अतुल भाई, सर आपने उन्होंने यहाँ पे हम लोगों के लिए इतना मेहनत करके सबको इनवाइट किया है। और अतुल भाई का भी हम लोगों को थैंक्स बोलना चाहिए, क्योंकि उन्होंने बहुत बिजी शेड्यूल्स में इसमें उनका टाइम निकाला है। मैं थोड़ा इंट्रोडक्शन दे दूं अतुल भाई का और बख्शी साहब का। सबसे पहले मैं बख्शी साहब का दे देता हूँ। बख्शी साहब तो डॉक्टर धर्मांग चंद्रकांत बख्शी, पॉपुलरली नोन एज डॉक्टर DC बख्शी। उन्होंने एजुकेशनल बैकग्राउंड भी बहुत अच्छा है उनका, मतलब कि उन्होंने MSc किया है माइक्रोबायोलॉजी में। देन ही हैज डन PhD भी माइक्रोबायो ऑक्यूपेशनल डिसीज इन फार्मास्यूटिकल्स एंड बल्क ड्रग्स यूनिट इन रिलेशन टू वेरियस लेबर लॉ। और उनका एजुकेशन जो है वो HR के जो होते हैं वो उनका प्रोफाइल देखते हैं तो होता है कि यार क्या प्रोफाइल है, मतलब कि बहुत लिक्रेटिव प्रोफाइल लगा। उन्होंने DBM किया है, डिप्लोमा लेबर लॉ प्रैक्टिस फर्स्ट रैंक से किया गुजरात यूनिवर्सिटी। LLB लेबर लॉ किया है फर्स्ट रैंक से। LLB स्पेशल किया है फर्स्ट रैंक से, डिप्लोमा कंप्यूटर साइंस भी किया है। इनिशियल स्टेज में उन्होंने थोड़ा बहुत टाइम इंडस्ट्रीज में भी काम किया है। देन वो हम लोग कहते हैं महात्मा गांधी लेबर इंस्टीट्यूट बहुत फेमस है, उनमें भी वो असिस्टेंट प्रोफेसर हिसाब से काम किया है। देन ही ज्वाइंट गवर्नमेंट सर्विसेज, गुजरात लेबर डिपार्टमेंट में उन्होंने स्टार्ट किया, और अभी लास्टली ही इज रिटायर्ड एज ए एडिशनल कमिश्नर ऑफ लेबर फ्रॉम गांधीनगर। उनके प्रोफाइल में और भी बहुत कुछ है, उन्होंने रिसर्च पेपर भी बहुत लिखे हैं, और ही इज फैकल्टी फॉर द निर्मा यूनिवर्सिटी है, गुजरात यूनिवर्सिटी है, बीके इंस्टीट्यूट है, और जुडिशरी एकेडमी में भी उनका मेंबरशिप है, और एक्सपर्ट कमेटी में भी बिल्डिंग एंड अदर कंस्ट्रक्शन और जो हम लोग कहते हैं उसमें भी उनका कंट्रीब्यूशन बहुत है। मतलब कि उनकी प्रोफाइल जो हम लोग चाहते हैं कि नहीं, लेबर में कुछ एक इमिनेंट पर्सनालिटी जो होनी चाहिए, जो रिसोर्स ऐसा इतना मतलब नॉलेज इतना अच्छा है सबका कि आई एम डैम श्योर कि जो हमारे मेंबर्स है उन लोगों को डेफिनेटली जो हमारा मोटो था कि कुछ अच्छा सा नॉलेज मिले, उनको कुछ शेयरिंग हो जाए, that will be definitely beneficial to us. Thank you very much, बख्शी सर।
थैंक यू, थैंक यू।
मैं अतुल भाई का भी बोल लेता हूँ। अतुल भाई तो ज्यादातर इंडस्ट्रीज वाले जानते हैं, बिकॉज he has worked with giant pharma industries like Cadila है, Torrent है, Sun है, and now he is associate VP with Intas Pharmaceuticals. अतुल भाई का भी he is having double bachelor degree, एक साइंस में भी है और लॉ में भी है। देन ही हैज डन हिज मास्टर इन लेबर लॉ, स्पेशलाइजेशन लेबर लेजिस्लेशन एंड IRPM। मतलब कि आज हमारे पास दो डिग्निटरी ऐसा है, आई कैन से कि नॉट डिग्निटरी, दे आर द एक्सपर्ट इन लेबर लॉज। आज हम लोगों ने ऐसे दो फैकल्टी को इनवाइट किया है, और अतुल भाई का पर्टिकुलरली मैं तो थैंक्स करना चाहूंगा अगेन कि उन्होंने ये जो हम लोगों को SHRP को ये मौका दिया है, उनके लिए उनके जितना आभार प्रकट करे इतना कम है। आई वुड लाइक टू हैंड ओवर अतुल भाई सर को। मैं रिक्वेस्ट करूंगा सर आप सेशन को भी आप हैंडल करें। थैंक यू वेरी मच सर।
Thank you. Am I audible?
यस सर, यस सर।
Okay. So thank you, Hiren bhai, for wonderful, inauguration and introduction of both of us. So, friends, those who are there as a participant, a warm welcome to all in this particular webinar. Now, we have been talking about this labor code for quite a long time, and around some time back, there was a final version we could able to see, wherein around 29 various labor legislation now merged and converted into 4 code. And I'm sure since we are from the field, you must be knowing, but still just to align you on those 4 codes. Those codes are Industrial Relation Code, Wage Code, Social Security Code, and Occupational Health, Safety and Working Condition Codes. These are the 4 codes now. Moving ahead will be a kind of way of our life. And because these are the new codes, if you look at the media, then I'm sure there will be many apprehension, and we have a different interpretation basis on the comment by various media on the provisions of the new code. And therefore, we thought that it is very much important for all of us, to understand the exact the interpretation of this code, because then only our life will be smooth in a time to come. So therefore we thought that let us arrange the webinar on a current live topic. And when I was talking to Hiren bhai in the morning, there were 500 around participants who have enrolled, which speaks about the importance of this particular topic on today's context. So let us understand from Dr. Bakshi, as very rightly said by Hiren bhai, that and particularly I know him very personally, and I would say that he is more academic than is a kind of government. So we are fortunate enough that we have a very learned faculty today, and with his a long 30 plus years of experience of government machinery, and even in some of the area he is catering to some academic institute also. So surely at the end of the program, definitely we will feel that we have gained correct insight, because correct understanding is most important thing in a today's context. So that is more important, and therefore I would request all the participants to focus on a delivery of the program, and at the end of the session, definitely there will be a questions which we are going to address. So if you have any kind of questions in between, then you can always write on a box which is there appeared on a right hand side bottom of your screen, so that we can handle those queries. Of course, it is all subject to time permits. So without taking much of time, I would request Dr. Bakshi sir to take it over from here. Dr. Bakshi, please.
Yeah. Thank you, Atul Bhai and Hiren Bhai. I think I am audible properly.
Yeah, perfectly fine.
Yeah. So I am indeed thankful to Crown HR Services for inviting me to deliberate on the various codes, to begin with the Code on Wages and Industrial Relations Code 2020. Now, before I touch the subject, in quick 2 minutes, I'll give how things have evolved. Somewhere in 1990, the floodgates of Indian economy were open, and at that time, the then Finance Minister and of late the Honorable Prime Minister, namely Dr. Manmohan Singh, has openly said that the plethora of labor laws needs to be revisited. Now everything, we are in 2020 and still an Employee Compensation Act 1923, the Trade Union Act 1926 is in full force. Now you imagine a situation in 2020, the legislation of 23, Employee Compensation and Trade Union Act, and if you look to the other set of labor laws, they are also nearly to the post-independence era, like minimum wage is 1947, 48, ID Act 1947, Employee Standing Orders, Industrial Employment Standing Order 1946, and so on. So having such situation, somewhere in 1999, the Second National Commission on Labour was constituted under the aegis of Ministry of Labour, Government of India, and the commission was given 2 terms of reference. The rationalization of existing labour laws. We will see in a slide to follow how burdened HR and IR professionals are with compliances of plethora of labour laws. So first was to rationalize the existing labour laws, and second to have an umbrella legislation for unorganized labor. I'll just incidentally say that I was fortunate to give a status paper to Second National Commission on Labour in 2000, and I was rewarded by the Government of India for that also. So that was the insight what we feel more as a blend of academics and working officer in the system, that what should be in days to come with reference to labor laws was the status paper I had given to Second National Commission on Labour in 2000. In year 2000. Now the Second National Commission has recommended the report on wage code, wage laws, law related to occupational safety, health and working condition of workers, law related to industrial relation and social security in June 2002. Now you know that the subject labor is on a concurrent list of the Constitution of India, and state as well as central has a say in having the labor laws befitting to their state's economy, geography, natural resources, nature of industry, and nature of workforce. Having said so, at present, I mean, before these codes have seen light of the day, 100 state and 40 central labor laws in force, and it was, of course, need of the day to reduce this. Second, the multiplicity of the definition like worker, employer, establishment, etc. It was a need of the day to the amalgamate the provision related to wages, social security, industrial relation, health, welfare, safety of workers of like-minded labor laws. In wake of that, as Atul Bhai has rightly said, 4 different labor codes were cleared by the Parliament of India, and Honorable President also have assented that. Of course, the formal notification of applicability of this code is yet to come, but this code has seen light of the day. The Code on Wages and Industrial Relation Code is the current subject where I have to deliberate today. The Code on Wages was passed on 8th August 29. The Parliament, that is Upper House and Lower House, had cleared that, and Honorable President has assented on 8th of August 2019. The preamble of Act is nothing but to amend and consolidate the laws related to wages and bonus and matters connected therewith and incidental thereto. If you look to the earlier set of laws, be it a labor law or any other law, you will find it extend to whole of India except Jammu and Kashmir. Now, being J&K integral part of under 370 has been waived, the stance it extend to whole of India. There is no except word. Then it shall come, which is this part is very significant, that code has seen light of the day. Government of India, with reference to wage code, has already framed the rules. State governments have taken the stand, and they are also in a lap of finalizing the rules under this wage code. But then the current situation itself come into the force on such date as central government by notification in official gazette appointed different dates may be appointed for different provisions of this code, and any reference in such provisions to the commencement of this code shall be construed as a reference to the coming into the force of the provision. So that formal notification is yet to come, but I can let you know incidentally that the officer deputy CLC at Government of India level, who was instrumental and doing all efforts in drafting this code, is good friend of mine, and we have interacted number of times while conceptualizing the concept and putting reform under the plethora of labor laws, which is merged now by way of different codes. So I can name the gentleman also, and probably somewhere in 2018 when these codes were fully drafted, but it was a draft form, probably one of the organization from Baroda, GEO, I don't fully remember, Dr. Malti Bard used to be CEO of that organization, had invited the gentleman who I am referring to, and I was also one of the party to the proceeding in explaining what is in pipeline. Now Atul Bhai has rightly said that after these codes have seen the light of the day, lot of material on internet is available, and a lot of print media is also putting their views. Lot of trade unions and employer association have also been started talking on the subject. But frankly speaking, the one who was integral part of the drafting the code knows better for which purpose this kind of provisions were made. And there are two issues while talking of code, be it a wage code, IR code, or whatever code. the procedural simplicity was kept into the focus without negotiating with the rights of the working class was the nucleus focal point in this code. So what my deliberation, this is just a preamble I have tried to build to enter into the subject, and my deliberation will focus on 3 counts. Number 1, I will be discussing or explaining or narrating the salient features of the code, and while saying so, I will also say that what was, I mean, of course, this code has seen light of the day, but that formal notification is awaited. But assuming that it has come into the force, my deliberation will, I'll discuss the salient features of the code. While saying so, I will say what was prior to this code, and third, how it is beneficial to HR, IR, fraternity and working class. We are member to International Labour Organization since 1919.
सर फागुन हियर, आपका कैमरा ऑन कर सकते हैं सिर्फ आप?
ओके,
कैमरा
या तो कैमरा कहाँ पे होगा इसका?
ऊपर जो आपके प्रेजेंटेशन के ऊपर माइक का सिंबल होगा उसके लेफ्ट साइड कैमरा है.
ठीक है, ओके, आई हैव डन इट, राइट?
Yes, sir. Go ahead, please.
Good enough. So I was just trying to say that we are member to International Labour Organization since 1919. So almost 101 years have been completed to having a member of the tripartite body, which has a headquarter at Geneva in Switzerland. And every year they assemble and they try to discuss various points, but my point of bringing ILO here into the discussion was in January 2019 we had completed 100th year, so there was a launch ceremony at Delhi and I was sent on behalf of the government, being I was functionary at that point of time. I retired in September 2019, so in January I was fortunate to attend that launch ceremony of ILO, and the Indian chapter was also fully involved under aegis of Ministry of Labour, Government of India, where they had also expressed the ulterior satisfaction about this merger of various labour laws into these 4 titles, of which 2 will be discussing. Now coming to the anatomy of the code. The code, which has been through by the Parliament, assented by the Honourable President on 8th of August 2019, has a 9 chapters and 69 clauses. And all these salient feature of code have been covered under the 9 chapters. As I have been saying always, the very purpose to merge these all labour laws was to remove the multiplicity of definition, to simplify the implementation without compromising with the rights of the and welfare of the working class. Now under Code of Wages, 4 different labour laws are merged. The Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act and Equal Remuneration Act 1976. Frankly speaking, this amalgamated version of Code on Wages have very few significant changes which has bearing on the performance of the HR and IR fraternity in industry. Well, I'm as in inaugural while introducing my CV, it was told I am associated with BK School of Management since 2004. In between I had to skip, being my office was transferred to Gandhinagar, and then again I have rejoined before a year or so, and I'm teaching to the integrated, in the morning and evening MBA batch as well as evening postgraduate diploma in HR based. But that's not the point which I was to tell. My focus was while talking to these management students, I have been always advocating that HR and IR, they are two sides of coin. Those HR professionals are participant to this will definitely agree that compliance of the legislation is the core area which nowadays become more important. So HR over and above the compliance, creates a right format in industry to, compliance of the labor standards as enumerated by ILO. Now, broad vision of this code is to adapt the technological change and dynamic factors in the matter related to minimum wages, national floor level wages, equal wages, bonus of workers, etc., etc. Now, things have been changing a lot. Jobs of human is being taken over by machine. The number of engineering units have put their base from various countries with a robotic operation, and that is why it was a need of the day to have a relook, or otherwise if you want to really globally compete, then you need to have something which less burdens the employer in terms of complying the plethora of things and to simplify the deed. So very purpose was to bring the transparency and accountability, which would lead to more effective enforcement, widening the scope of minimum wages to all workers. The current situation is only minimum wage is applicable to only those scheduled employments where 1,000 or more workers have been engaged. That's the provision of the minimum wage. Now this code provides something different that we will see at that appropriate time, that neither organized workforce or any unorganized workforce should left out from the ambit of the minimum wage. Now followed by this, the facilitation of ease of compliance of labor laws will promote in setting up more enterprise, and that's catalyzing the creation of employment opportunity is the broad vision. Now it enables Falgun by something wrong, it disappears from the screen.
Okay.
See?
Yeah. One slide is missing, sir?
No, nothing is missing. It's all fine tuned. This is my actually on the code. This is my 5th program.
No.
The point is the same PPT I've been using. That
Okay.
was the code message.
Just a second, sir. Give me a second.
You may adjust that, but putting in lighter side of the issue, the byproduct of pandemics is webinar, and some WhatsApp message was percolated, a breaking news that today there is no webinar. So as many as 7 to 8 links, those who are in the field of academics or in a professional career receive the link of webinar, but of course not attaching those with this current scenario, that it really.
Sir, can you change the slides now?
I'm doing it. Yeah.
Is it okay now?
As of now, okay.
Okay, sir. Okay. I will be here only. So मेरा full concentration रहेगा ये. कोई issue आता है तो मैं I will be available. Okay.
Please. So this is what I was trying to speak. It provides for essential element for wages equal. That's what we have discussed. So yet it enables appropriate government to determine the minimum wages shall be fixed for different categories of workers. And normally while fixing the minimum wages, what was being visualized, the 5 criteria: food, shelter, clothes, health and education. Now the element of skill is also added into it. Geographical location of the workplace and other aspect which appropriate government consider also have some weightage in fixing and revising the minimum rates of wages. Then the timely payment of wages and authorized deduction from wages which are presently applicable in respect to employees drawing wages of 24,000 rupees per month. Now I will quickly link here, as I have said, that what was past and what is now and how it will be useful. That three segment I will be always talking when I will feel that it is worth talking. The Payment of Wages Act is applicable to only those employees having salary per month, that is basic and DA, up to 24,000. Now that seal has been removed and the all kinds of features are made applicable to all employees irrespective to wage ceiling, and appropriate government may extend the coverage of such provision to government establishment. Also, that's the additional feature has been made. The wages of employee may be paid by check through digital or electronic mode by crediting into the bank. Now, somewhere in 2016, demonetization was done, and at that time, those currency which was in force was in a gradual manner withdrawn by the Government of India. And at that time, the number of issues related to the payment had come across. Of course, Gujarat being a thoughtful state and always innovative in such area, in 2015 December, a year before, I don't know some of you are aware of or not, but the government of Gujarat has made amendment that the payment of wages is mandatory through check or ECS in a digital mode to the establishment employing 20 or more workers. Now this code, the Deputy CLC, namely Dr. Onkar Sharma, who was instrumental in drafting this code, as I said short while back, he was in live touch with me, and then he acknowledged that this is the right way to deal with while drafting the code. On numerous issues, I will cite that, and I will further scroll the slides while explaining you. So first significant change from your point of view is payment should be statutorily through bank or a ECS or a check, whatever So that's must is the issue. Second, it provides for floor wages for different geographical area, but I will explain this in this way. National Commission on Labour has suggested that there should be some cutting edge level of wages. Now, what is happening? I tell you, when as a part of my job, I had attended Indian Labour Conference at Delhi for almost 21 years, where I used to see that some of the states have the Minimum Wages Act, which was not worth citing, because in that amount nobody can sustain. Now labor being a subject on the concurrent list of the Constitution of India, state as well as central can enact and fix and revise their wages. So there was no constitutional breach theoretically on the subject, but if you look to the Article 43 of the Constitution that provides for the living wage, that was not being well addressed, being so meager wage. So government, the Second National Commission has recommended that there should be some floor level base wages, and none of the states in the country should be allowed to fix wages, minimum wages, less than the national floor level wages. That was the the core area of now it was a concept, now it has been legalized. So it is a statutory that every state or union territory cannot fix the minimum wage less than what will be the national floor minimum wage, will be fixed by the Government of India and revised time to time. Second, to remove the arbitrariness and malpractices in inspection, it empowers appropriate government to appoint inspector cum facilitator in place of inspectors. Now, friends, I will let you know that somewhere in 2003, Government of Gujarat Industries Department in collaboration with Labour and Employment Department had developed a policy that inspector should behave like friend, philosopher and guide, and not like a typical auditing person that when somebody comes, we develop a fear as a private entrepreneur that what fault he will find and how much notices he will issue to us. Now that part was a policy matter. Friends, I will tell you, policies are policy, but when policies are supported with a legislature, it has the nail to bite. So policy is a very much ideological thing, but in this code it has been legalized, and the term inspector under the act has been replaced by inspector cum facilitators, and their role and responsibility will be to supply information, advise the employer and workers. So as I said, a friend, philosopher and guide, not a fault finding, and so on. Then very significant thing in the code is the ceiling of age limit for the purpose of eligibility of bonus and calculation is vested on the appropriate government. A good news for employees that at present the ceiling is basic plus DA, that is rupees 21,000. Now that ceiling will go off, and appropriate government will determine that ceiling. So in a lighter part of this, I will, while talking to Atul Bhai, I was saying that for employer, we all are employees, but government, we all are over and above employees, voters also. We have something sensible to say by voting during election. So I am sure government will not displease in raising the ceiling of wage limit for the purpose of eligibility of bonus and calculation of bonus. Then in the present code, number of authorities at multiple level have been reduced to hear and decide the claim under the proposed legislation. Friends, you know that. For an example, I am not paid with a bonus, or I am paid less wages or less wages as compared to the minimum wages, or I have not been paid at all. Then the recovery was a mode under the labor codes. Here format is changed, and the government has authorized the officer at the rank of under secretary or equivalent to that to hear and decide the claims of non-payment or a less payment of the dues or bonus, and of course it will speedily decide the thing. I tell you, friends, in my career, whatever time I have put my entire career mostly in head office, and Atul Bhai has rightly said that I'm more a teacher and academic kind of person, but whatever little opportunity where I had in the field, my way of talking was with both the stakeholders, the employer and employee association, that is trade union, was to try to settle your issues within your premises rather than to prefer the litigation. But since the very restricted power the government machinery has, for an example, in ID Act, that we have only conciliation powers. We don't have adjudication power. So we cannot adjudicate the matter. We have to refer simply to the labor courts or a tribunal, as the case may be. Now this will be diluted here, and we will have the opportunity to settle within the government offices. Then the claim filing period and the onus of proof. For an example, if somebody has raised the claim for filing the non-payment of remuneration or a bonus or a less payment of wages or a bonus or on account of making deduction not authorized by the proposed legislation, the burden shall be on the employer to prove that the said dues have been paid to the employees. This is legislated thing. That try to understand two things here. I will be repeatedly saying. Government policies, circulars, GR, they're okay. It's all right. Just I'm theoretically saying. But when the policy procedures are supported with the law, the central enactment, it has its own mileage and leverage in support of the employed class. So, there may be a lot of, articles people have put on web or any print media. But, if you really try to understand into the depth of the subject, it is of course, it has tried to balance the act by diluting the procedures, Inspector Raj abolition or dilution of Inspector Raj, use of technology we will see when we will process further this presentation. But, at the same time, they have closely looked that the rights of the employees are not negotiated. Like, the time limit of, payment of wages, if the employee's strength is 1,000, up to 1,007th of the next month, and if it is more than 1,000, then 10th of the next month. Now that has gone. We will see in slide to follow. Irrespective to any strength, one has to pay salary on or before 7th of the next month. Then we have seen the deduction and the 24,000 seal also have been removed. So this is legislated thing which definitely favors the employer. Then the bonus, ceiling of bonus to be decided by the appropriate government. Compulsory payment through ECS, check or a bank. Of course, some rider has been kept. For an example, construction industry workers, there's a different pattern there, that they require every weekly payment or whatever, and they don't have any accounts in the bank due to migratory nature, etc. Then government has reserved the right to do that. But the point I'm just trying to say that it has really tried to strike a balance. Then, yes, the pattern of the advisory board, which was there in the minimum wages at 1948, and I don't know, some of you are aware about that in employee compensation, Equal Remuneration Act, there is the advisory committee which decides the employment, and there should not be any discrimination in wages and employment with respect to gender. So that is being well continued here. The filing of claims before the authority. Now the judiciary has gone from the surface, is enhanced to 3 years as against existing time period varying from 6 months to 2 years. Friends, that under the provisions of the Minimum Wages Act, those who have come across any trade union which has filed recovery against their organization, and you or your retainer attending the labor court, the recovery should be of last 6 months up to 10 times. Now that period has been enhanced. Certainly this is the friendly for the employee class. Up to 2 years it has been, what then. This is a significant amendment which I was just trying to speak to Atul Bhai once in an academic discussion, that power to file the criminal case against offending employees also vested on worker and trade union. Now I'll take a 2 minute extra in explaining this matter. While talking to judicial officers as I'm teaching labor laws and constitutional law to the judicial magistrate first class junior division civil judges at Gujarat High Court in their academy since more than 17 years. While interacting with these people, and of course while my initial job was as a court officer, Hiran Bhai, while talking of my biodata, I am postgraduate in microbiology, and then while working in industry, I came to government through GPSC. So at that time, my first posting was in court office as a court officer. And I used to see that, the type of, offenses which the entrepreneur representative are doing by non-maintenance of records and this and that. Some complaints here and there, and government has no choice but to file the cases being, the HR fraternity or IR fraternity has not complied some, document part. So, and the all government officers were put to a trouble because people are not equipped to establish the criminal offense being, fully dominated by advocate fraternity, and it was very difficult to, establish the offense into the criminal code. So, this was all being well discussed while interaction with all judicial officers, as I shared while being at Judicial Academy in the ambit of Gujarat High Court. I felt that, why government should be in between. Now, I'm coming to the point. For an example, there is a complaint against some company by some union. Then present practice, once this code will roll out by way of formal notification, present practice which I'm going to tell now will go off. But at present, what is the practice? For an example, award has not been complied, layoff has been given without permission, or company has been closed down without permission, or unfair labor practice has been exercised, or bonus has not been paid. Then the matter reached up to the Labor and Employment Department. In some cases, the secretary used to give a sanction to file the criminal case against the offending employer. In some cases, Labor Commissioner gives the permission to file the criminal case to the class 2 officer termed as a government labor officer. And of course, under some labor laws, government labor officer himself is empowered of the given area to file the criminal case. But that's the format I'm just trying to say. Mostly, cases are filed based on the complaints of the workers or a union only. And now officer files the case and he becomes complainant and attends the criminal court time and again. So a much debated issue was why government should be in between. The one who has complained, a union, let them empower to file the case. Government will give the sanction to the given union or a worker to file the case into the criminal court, and let them face the music of, how criminal courts are functioning. Because, as a court officer, and of course, for 17-18 years interaction with all judicial officers who've been working across the state in a different basis, it's very difficult to deal with in criminal case to establish the offense, and the officers are put in a worse situation. But if the debate is raised on this particular point, how far it will be good from the employer side, that once trade union will start attending the criminal cases when government start empowering them. Of course, that is why case against offending employer is also, that is in addition to the present situation on worker and trade union. But that's the amendment is one with a simple objective that let the worker and trade union at least once they should attend the criminal court. Those who are attending the courts in a present gathering will agree that the labor courts are all JMFC and JDCs are working on deputation in labor courts, except few recruitments of like 5-6 judges which was of Labor and Employment Department in those era. Remaining all judges they work purely on CPC, CRPC, Indian Evidence Act. And I can tell you, friends, on a statistics that in spite of industries are increasing, the number of complaints and filing in labor courts and tribunal, and even in Honorable High Court with reference to labor matters, are reducing. In fact, it should increase because more the industry, more the worker, more the dispute. But that's not happening because the concept of social legislation has been fully taken over by judiciary purely on evidences. So that's very difficult for people to establish the work to the third stakeholder, that is a trade union and employee organization. Maybe the one solid reason that this is happening. So anyway, this was just I wanted to elaborate. Then this I have said in a previous discussion that the appointment of officer not below the rank of under secretary. Now, for recovery, Worker need not have to go there. Employee for their bonus and other thing need not go there. And then officer has been also empowered to impose the penalty. The most significant, which I would like to say, the next bullet, it provides for compounding of those offences which are not punishable with imprisonment. You know, if you are aware of any penal provision into any labor laws, this kind of words you will find. The offending employer will be penalized with fine not exceeding X and imprisonment and oblique or imprisonment of 3 months, which may extend to 6 months, or with both. Something like that you will find. But here, the most significant thing, which is definitely useful for all employers, to do away with the criminal trials. Now, how that I will explain quickly, because after 10 minutes I will have to switch over to another code, as I have to wind up within at least 1 hour and 50 minutes, so you people can have any question, I can satisfactorily answer you. But the point is, compounding of offences was the most significant thing. I don't boast myself, but in 2015 December, state government has done that. I have addressed the labor reforms done by government of Gujarat by way of state amendment to at Baroda, Surat, Vapi, Rajkot, Kutch, Ahmedabad, and maybe Valsad also, I forgot that, and of course one at Bharuch. And the one of the leading organization of Baroda, I have forgotten the name. Anyway, over and above GEO, I have addressed this. While saying so, my point is, this amendment of compounding the offences we brought in 2015 December. Now in developed countries, these offences are settled by economic means. The element of criminality, you see, in a loud statement I used to speak among the judicial officers, violation of all labor laws amount to criminal case. You might be experiencing or facing this as a part of HRIR fraternity, but this is the settled situation. Now, I was court officer when I said some time back, I had a thought galloping in my mind. In criminal courts, the person, you know, have attempted for murder, the person who has violated the Narcotics Act, person who is involved in domestic violence, and besides that, a HR manager who has not kept few records and registers. A thought was really, you know, jumping in my mind, that can a potential criminality be equated at par with the remaining 3 cases an HR head or IR head or a labor welfare officer or HR general manager or whatever designation, for simply not maintaining the records and registers and so on. Does it sound well, was not acceptable to me during those days when I conceived in the department. Somewhere in 2014-15, I got the opportunity. I punched before the present, our chief minister, who used to be our labor minister at that point of time, and I convinced the gathering in my presentation that this is too much. So then one of the senior bureaucrats agreed that in developed countries it is settled by economic means. There is no potential criminality involved in it. But then we had some riders. I will not touch that, but this compounding of offences is very significant amendment that one must explore after once this code has been rolled out, and that it provides for even after institution of offences. Suppose some of you are not aware about this compounding, then some officer has filed the criminal case, you can give a pursuit to the court where the case is pending and restore into the labor commissionerate office, and whatever, you know, fine that rules will decide within few weeks, you have to simply pay and forget about it. So that's the creative. People need not attend the criminal courts for this kind of offences, but this is restricted to only those where there is no element of imprisonment. right? Only penalty where it is provided. Of course, there is some rider also have been created of late in this. So anyway, so that was all with reference to this. Then I have tried to put few definitions which are significant and you will not find, or amended definition which you will not find in the legislation, just to strengthen you. You know, the present situation is theoretically, ideologically, you cannot recruit a contract labor in permanent nature of work. Otherwise, you know, the contract labor advisory board and abolition of contract system and all the, you know, sequence of event one has to face and so on. Here, you know, I have tried to put into the bold way the word uses for any work of the establishment. So it is not restricted to that it should be core activity or non-core activity. Of course, I'll speak here with some different dimension. You know, labor laws have some, you know, peculiar situation that there are interlinkages of labor laws. Now, on 12th of October, I had deliberated on Occupational Safety, Health and Working Condition Code, where contract labor is merged into that OSH code. As many as 13 labor laws are merged under OSH code, where, you know, the government has defined the core activities and non-core activities. It means a blank check is given to entrepreneur that you can comfortably recruit the contract labor in non-core activity, which has been defined. Act has defined. Somewhere in 2003, government of Andhra Pradesh has tried to define that. We also tried that, but then, you know, we could not see that comfortable, which somehow government of Andhra Pradesh has did, and our file was junked into the legal department. So anyway, that's not the point. Now it has seen light of the day. So very purpose is the contract labor. Contractor is no restriction to provide the labor for any work into the establishment to produce and given a result for establishment. And the contract labor, the one significant change has been with or without knowledge of the principal employer and includes interstate migrant workers. Now, you know, again there is linkage with OSH code. Now, I'll quickly link and then we'll go to the next slide. That, you know, in current pandemic situation, I'm sure you are aware that as many as 20 migrant workers were transported by Gujarat government to their native states. And there was no check and balance system that how many migrant workers from which state have come to Gujarat. All of you know that in certain industries, certain products, certain processes, Gujarati workers are not comfortable and you will never find there. I have worked across the board for reasonable period of 7 years and then in 30 years in government machinery. May not be in an executive function but with the head office, but I still understand that migration is a way of life and people from underdeveloped state tend to migrate in search of livelihood to industrialized state, and so has happened with Gujarat, Maharashtra and Andhra Pradesh and Tamil Nadu during this pandemic. Now that's not the point, but there has to be a tracking mechanism. The current act which is merged under OSH code, that is Interstate Migrant Workers Act 1979, has some different peculiar situation for tracking of migration from one state to another state. Now that has gone, and why I try to link here with the OSH code, because OSH code provides for a dedicated portal for those, you know, entrepreneur employing 10 or more workers having a migrant workers. That migrant worker should upload his data with Aadhaar card. And of course, the ration card to migrant worker, for an example, I have migrated from Rajasthan to Gujarat. Then the ration card of Rajasthan will be, you know, useful to me in getting rationing in Gujarat also. So portability of ration card, that was, you know, that was not there in earlier draft of OSH code, but due to pandemics, the horizon of thinking were, you know, raised and sensible amendment was put in practice. So that's what I just wanted to say. Then you will not find any definition of employee, only worker. And that employee definition, they have included supervisory, managerial, administrative, technical, and clerical. This is which was not earlier there. And to give a broad horizon, also include a person declared to be an employee by the appropriate government. The contractualization of employee is not only practiced in the private entrepreneurs or so on. It unfortunately has become a way of life in the government institution and government machinery as well. The term may be whatever, nomenclature may be whatever, that outsourcing of employees or contracting out, subletting the work, that's all nomenclature, but then all gully leads to one highway. That yes, it's kind of contractualization to give them a reasonable status. The term employee, which government also can, whatever they prescribe needs to be included and so on. Then employer definition is of course there in all the legislature, but to give the wider coverage, as I said, that there has to be a protection of outsourcing employee, which has become a way of life in government, local bodies, corporations, etc. They have tried to define the employer, to whom to sue, whom to make responsible for the offense. If I just a little shift from this discussion, if I have to give the data of number of awards published by the labor court on complaints of reinstatement, at least 30% is accounted by the roads and building department, forest department, irrigation department, so on. So there has to be some, sense of governance and accountability on the side of government. So in definition of employer, establishment is carried on by any department of the central government or the state government or the authority specified, or head of such department in this behalf, or where no authority is so specified. And in case of local authority, the chief executive of that local authority is put in the definition of employer. Then the first time this definition also you will not find in existing set of labor laws. Government establishment, then I said that inspector come facilitator, same work, same nature, or same work or work of a similar nature. Of course, it's nothing retrieved from the Equal Remuneration Act, which is, the central objective is no discrimination while having an employment, and remuneration should be at par to that both the set of workers, male or a female, without any, gender discrimination. So that's all was with reference to that, and of course with condition of employment. Now I also will put one thing here while talking of equal remuneration and gender discrimination. Some of you might be aware that before 4 or 5 years, one public interest litigation outlet converted into the special civil application was made by the female employees of Balaji Wafers, the unit at Rajkot. The very purpose of the litigation was they were trying to focus on Article 16, 15, 3, 14, that right to equality, and their demand was, their prayer was, that we also must be allowed to work into the night shift. You see, we also have a share in economy. We are also earning members of the society and our family. And yes, there is nothing wrong. Why there is a ban under the statute to not to allow us to work into the night shift? With that contention, and then the first time in the history, if I have to say that, Tamil Nadu government has amended the Factories Act by way of state amendment. As I repeatedly say, labor being on a concurrent list, state enjoys the power to amend the law, and accordingly they have done it. Now trying to say that, which I have said short while back, interlinking of labor codes. The OSH code provides for you can recruit the female employees in night shift, as Factory Act is merged into the OSH code. So that the horizon of right to equality have been truly addressed, of course, with some rider that consent of a female employee, transportation and security of the female employee. It's okay, it's or otherwise sound well. So anyway, so that's the try to balance the gender in equilibrium in terms of employment market. Then definition of wage is all right, but they have added the retaining allowance. Now I was just asking to Dr. Onkar Sharma ji during the last interaction in January 2020 and abroad, when this code was passed on 28th September, not this one, the IR code. Also, I congratulated him, he reciprocated that now we are on a mission mode to make the rules, and I offered that if you need any help, I am at your disposal. While saying so, I asked him that you have expanded the definition of wage. Normally, whenever you look to any law, be it a labor law or any other law, any words which are of specific nature are mentioned, then in definition section it has to be defined. Now, where I wonder, retaining allowances word has not been defined in the code, so that's the area of concern which I told him, and then you may find some minor amendment in days to come. But anyway, this is just to enlighten you when I'm talking on the subject. I say that second thing, the definition of worker, rest of the part is all right, but two categories of workers which were missed out of the ambit of the definition. That is, one is a working journalist, that is newspaper employees. There was one dedicated, there is, of course, as of now, since notification has not been, I just said was not a big subject of choice. But Working Journalist Act 1955 was in force. Now, it's a specific legislature for a given class of employees. Now, since everything, the amalgamation process is there, they have put this working journalists, newspaper employees, and sales promotion employees were unfortunately left out of from the labor laws, as there was a dedicated act, Sales Promotion Act 1976. So they have included this into definition of workers, so they get the umbrella of the benefit of the whatever has been prescribed into the wage code. And of course, rest the supervisory nature of work and so on, they are out of it. Then significant one thing they have done is time rated and piece rated minimum wages. Now this was, I'll tell you, the certain industries like in textile industry, some bobbins are used which are mounted on machine. The bobbins have the threads of different colors and so on. It's time rated. Then brick clean industry also per 1,000, this is the rate. Similarly in piece rated in sugarcane cutting industry and so on. We have identified as many as 7 to 8 industries where time rated and piece rated wages are there. But while deciding the piece rate, employer used to decide piece rate, piece output to such an extent that it was beyond reach to any sturdy worker to complete that piece to get the real wages which is prescribed. So that they have included into the code. So whatever time rate, whatever piece rate, whoever decides should not be less than minimum wages fixed for the 8 hours of the work. Then this thing I said that irrespective to any limit of wages, any strength of employees, wage is to be paid on or before 7th of the next month. Otherwise, there were 2 brackets, less than 1,000 up to 7, more than 1,000 up to 10. So then this I said that salary limit for the bonus will be decided by the appropriate government ceiling. So I mean more, Then, on this peculiar amendment, if you look to the Payment of Bonus Act, you have not legally entitled. The law does not provide. The present Payment of Bonus Act 1965 does not provide for any deduction except advances or a puja, not even advances, payment towards puja bonus. Only one can, deduct. That is the current provision. Now, the law has been amended, this wage code, that if I am found guilty of misconduct causing financial loss to the employer, then it shall be lawful for the employer to, deduct the amount of losses from the amount of bonus payable to him by employee under this code. So, of course, this is inspector come facilitator. I have said that in 2003, government of Gujarat has the, friend, philosopher and guide policy, and inspector should behave in this way, that way. Gujarat was only a state in that era, somewhere in 2000. We only a state in the country where we had one national seminar on abolition of Inspector Raj, that inspector should, but the outcome and the recommendation, I'll quickly say that, law themselves are not bad. Laws are good. They are enacted in a true letter and spirit, but the inspecting device needs to be groomed in terms of their behavioral science, moral, character, etc. Number one. Then, I have been talking in some B schools that even in judiciary also, that where there is a discretionary power to the authority, it gives a birth to corruption. If I have those powers that I can do this, I can reject your application, I can accept your application, I can give concession in your application. If those discretionary powers are with me, then yes, it gives me enough room to, the corruption, mala-fide practices. So now what has been done is, the way-to-base inspection has started. Of course, Gujarat always a state way forward and advanced, that we have a mobile application. If some officer come to your place, he has to upload the data within 24 hours on a real-time base. He has to upload on a real-time base that where he has gone, and it's with GPRS tracking. And where he has to go, that he is not supposed to decide. For an example, I am an officer looking after Makarpura GIDC in Baroda or Sanand GIDC in Ahmedabad. For an example, the system has a base that how many units are there in Sanand GIDC or Makarpura GIDC. And then system will pick up, software will pick up where I have to go and will send that names of those factories in my mailbox, and I am empowered or entitled to go only in those units. So this has definitely diluted the, the powers of discretion with the cutting edge level officer, and that is also on a randomized way it has been done. Then yes, some duties have been vested. Is job to advise the workers relating to compliance with the provision of the code. Now this was also a part of our industrial policy 2003, and of course now there are two more versions have come, so it's been further strengthened. I have been strongly advocating, and I will put a word to all HR fraternity honestly, that compliance is always preferred than litigation. You see, try to address the spirit of the legislature and see that it is compliant, and that exactly we have been preaching and teaching to cutting edge level officer. Do away with the litigations. It does not yield anything. If I make a statement that during my career I have filed 500 cases, is it worth? Or if I make a statement that I have made 50 employers to comply the law, then I have my own understanding and statement that later one sounds well. So that's how the policy framework. So grooming of inspecting device, guiding them properly, that you work this way, you work that way, and that is how the system will flourish and will be more transparency and everything. So that's what that is what then the offenses and penalty. I have seen, I have told in my previous slides that just read the dark. An officer authorized in this behalf or by an employee or a registered trade union registered under the Trade Union Act, government can, delegate the powers to file the criminal case to this much, either of these, authorities. So, of course, the cases are filed into the judicial magistrate first class. Gujarat is a typical situation. Just while talking to this, I will say that now after 2002, the Maharashtra Bar Council case, the labor courts are also the court, and that's why I said short while back that judicial magistrate first class have been asked to work on deputation into the labor courts, being fully equipped with CRPC, CPC, Indian Evidence Act, and etc. etc. So here the Honorable High Court has said that now somewhere in June 2017, all the criminal cases for violation of labor laws to be filed in labor court. So here Gujarat we differ, will accommodate into the rules. But this is what just I am trying to put here. The cases are to be filed in JMFC or so on, right? Then I said that instead of going to the court, some powers have been vested. I have read in my previous slide that the officer of the Undersecretary or equivalent state level officer of the Labor Department, who is in a same salary grade, a class 1 officer, has been empowered to impose the penalty. You see, and that amount has been prescribed. I am not reading it. And this is very significant. I have earlier also said that composition or its synonym is compounding of offenses. And most significantly, you should read an application of accused person either before or after the institution of prosecution. This means once the notification of rolling out this code comes into the service, and if some officer files a criminal case, you can definitely submit a pursuit to that court to compound the offenses. Compounding amount with reference to state amendment which we have done in 2015 December. Now it's a big question to state government also, what will happen to those amendments, because we have done something different into central enactment in 2015 December, where compounding we have introduced and we have defined the compounding amount also. But now what will happen to that amendment, that we will seek the legal department's advice, or we may reproduce that content into these rules under the code. So anyway, that was just incidental, but that compounding will do away from attending the criminal case, but rider is not being an offense punishable with imprisonment only, or with imprisonment also fine, may on application to the accused person either by be compounded by gazetted officer. You see, that's so imprisonment wherever it is, or imprisonment will file wherever it is not allowed. Otherwise, you can go for the compounding. So this is what, with reference to the wage code, I have to, I try to elaborate the major changes, what was there in past or recent past, and what will be in time to come, and pros and cons of what was and what is. I try to analyze. Now I don't know. I request Atul bhai, do we take question right now, or I should continue with the presentation of IR code? Your speaker is off.
Yeah, okay. So now I think I am audible.
Yeah.
Right. So I think primarily there are not more questions, but there are two questions.
Okay.
And those questions are related to enactment about the rules, that when the rules will be framed by Gujarat government and when it will be effective. So any idea on that? See, if we can provide.
The Honorable Minister of Labour, namely Santosh Gangwar ji, has said in one press conference that the government of India aims to have the formal notification of this code by December. And some print media use also said by April 21. Now, you know, but having the press conference which I have heard, I will go by that December is the, you know, timeline, and May from January 2021, it will come into the full force with a formal notification. And with reference to the rules, Government of India has already framed the rules. State government is, you know, framing the rules. But there are some issues, as I said, that couple of amendments we have done by way of state amendment, and how to integrate them into the rules. So that's the status of it. Right?
Okay, great. So now, if there are no rules, but still the notification will be applicable, or is it executable?
No, see, you know, here on my second slide, I have mentioned cleanly, categorically, and
Okay.
clearly that
Okay.
Government of India will see code have been passed by the Parliament, assented by Honorable President. So it has
Correct.
seen light of the day.
Correct.
Only the date of applicability, for date of applicability, there is always a formal notification.
Correct.
That this will come into the force from this date. Maybe, you know, chapter wise also notification come. To begin with, they may say that minimum wage, then they may say that this, like that. I don't know how they are thinking, but this is the situation. So,
Correct.
but by January 21, I'm sure it should see light of the day fully by way of formal notification.
Okay. Great. Just a minute. Now, one more question. Does GOI has planned to increase the awareness among the employees of these on a labor law changes? Yes, as a part of, I think, the process, there must be a awareness session by government, which the government officers are going to undertake in a time to come. Am I correct, sir?
Yeah, in fact, you know, every state should take a lead. Of course, right now the whole world is passing through different situations. But if I share the government of Gujarat, attitude to generate awareness.
Correct.
When in 2015 December we came out with the state amendments, which I'm referring time and again, I was the key instrumental in doing all this. I got it sanctioned 8 lakhs rupees to address the various industrially developed states. Few of them I try to enumerate that I had addressed to Rajkot, Morbi, Kutch, Surat, Vapi, Valsad, Ankleshwar, and Baroda. Baroda had a two different thing. And anyway, that state has to take initiative to give some budget, and then officer will move around and give the address to the all people. In fact, as a part of that, Atul bhai, your good initiative, I have passed on the link to some trade union people also.
Correct.
Because they should understand really.
Yeah, absolutely.
Yeah.
Correct.
So anyway, right?
Yeah. So I think we are under the pressure of time, and in fact, now it is a time because we are left out with, I think, hardly 40 minutes or so. So let us switch over, because this is the most important, code out of this for industrial relation code. And I am sure out of the participant, there are people who are responsible for industrial relation scenario for their organization. So let us go on our next code.
Okay. Now the same few slides are similar, repetitive, as it builds a base. But I must thank the Crown HR services to have this deliberation. As you can see on the first bullet, that it has been rolled out, and Honorable President assented on 28 September 2020. So it is just within a month and few days you could organize this in interest of your member. So that's one of the best thing being done. So as much as you are updated with what is happening, will be useful to you and your organization in days to come. So the preamble of the IR code says that an act to consolidate and amend the laws relating to trade unions, conditions of employment in industrial establishment or undertaking investigation and settlement of industrial disputes. Now that's the preamble, the core aim and objective of this act. Now it extends to whole of India. That fraction has gone which used to be there prior to the 370 status. It shall come into the force again. Same thing applies here. It has not seen light of the day in terms of functional force. We are awaiting the formal notification. I'll tell you the draft rules of Government of India I have received today, and then based on that the state government will also articulate how do we go ahead about in rolling out that. But this formal notification is mandatory with reference to finally rolling out this code. Now the anatomy, if I say that it has a 14 chapters, 3 schedules and 104 clauses, so it is much larger in terms of clauses and chapterization as compared to the wage code, and the core and salient features have been included in these 14 chapters. The very purpose is to remove the multiplicity of definitions of authorities without damaging the constitutional right of the worker. Now 3 acts which are existing as of now have been merged into the IR code. One is the most significant act, that's Industrial Disputes Act 1947, Industrial Employment Standing Orders Act 1946, and the Trade Union Act 1926. Now the salient features, if I quickly elaborate, 18,000 rupees is the salary, or an amount as may be, includes the person in supervisory capacity getting wages up to 18,000. Then the fixed term employment, regarding this act, frankly speaking, lot of material is available. Government of India has initially rolled out this bill in 2019. That version and there its analysis is also available. And 2020, that is 28th September onwards, that is in a spread over of 1 month and 5-6 days, also available on web or internet in some sites. But the basic here, it is a blend of theory and practices. Theory is one thing, and if I purely discuss this issue theoretically, it will not yield anything. It has to be blended with the practice, that how things are happening on the floor. Now, having said so, the current this IR code provides for fixed term employment. Now actually, if I debate separately for this word, those who are aware of the section 200BB of the Industrial Disputes Act, that provides for contractual employment, means on the expiry of contract, suppose I have a 1:1 contract, and I am by way of that contract I am for 1 year. Then at the end of 1 year I will have no right to file the complaint of reinstatement. But that was visualized as the exploitation of the workers. So somewhere in 2006, Government of Gujarat, by way of state amendment, we came out with a fixed term employment concept, and of course we amended the Industrial Employment Standing Order. But then that was much was put to the controversy with a limited context, that there was a change of government at national level, and the government where significant constituent partner was a left wing, and then this was put to so this was not much effectively marketed by the government due to various reasons. But the fixed term employment, the employee will get the benefits like that of permanent, including gratuity. except for notice period after conclusion of fixed period and retrenchment compensation. So all the social security benefits to the fixed term employee needs to be paid at par, and other benefits also, like a permanent worker, but his tenure is fixed, and once that fixed tenure is over, he has no right for retrenchment compensation, notice period, or reinstatement cases. The employer has been provided with the flexibility to employ the worker on fixed term basis. You know why this has happened? I'll tell you some genesis of the subject here. That as the Hiranbhai said, I had worked for 6.5 years in industries, and I was a QC head. I was analyzing pharmaceutical products, of which one tenure 2.5 years I was at Kandla Free Trade Zone, which is at Gandhidham. It is the first export zone. Now there are a number of SEZs and so on. I'm not touching that area. But in free trade zone or export based industry, you don't have orders across the year because it is banking on export potential. So in that case, there was a demand from the entrepreneur association that they need to be given some comfortable breathing space for a survival, because in a labor intensive industry, in absence of order, how long employer continue to pay the wages to 100? Anything wrong? Falgun bhai, can you intervene? There is some noise in between.
Yes, sir. Let me check.
Yeah. So anyway, so that was the big issue, that the export-oriented industries were asking for some concession in absence of order, and that is why fixed term employee term was coined. Now definition, I will not much speak of industry, but I will say one thing here while talking of industry definition has been decided and defined in Bangalore Water Supply and Severages Board versus Rajappa case. It is also popularly known as a triplet test judgment, a systematic activity, cooperation with the employer and employee, with or to satisfy the human need, and with or without motive of profit, that is all right. But at that time some notification was put into the legislature, but from which date it will come into the force was not mentioned. So till the date, whatever you imagine while answering this triplet test was falling within the definition of industry. Now with present code, with certain exceptions, means some charitable organization or non-profit making organization or some social services organization will get the benefit from getting away from the definition of the industry. So that's the one significant area has being tried to address by the lawmakers here. Now second thing, the various kinds of strikes, as in a course curriculum we have studied go slow, pen drive, pen down strike, and this strike and that strike. But if the worker assemble together and go on a casual leave, some percentages are stipulated, we'll see in the slide to follow. Also they have tried to put under the ambit of strike. Then somewhere in 2010, couple of amendments were made before 10 years in IDA, where grievances redressal committee was mentioned. Now they have tried to strengthen its base by giving the proper weightage, because they strongly in IR fraternity, in industrial relation, I always advocate in any classroom that if the issues any industry have, it is always good if they settle within their premises. One should not cross the boundary of premises, and it's a secret to success. Maybe in Gujarat, the different situation as compared to other part of the country in terms of industrial peace. But this kind of strong preaching and advocacy I used to make to whoever comes before us. So grievances redressal committee, there are a number of authorities, works committee, JMC, and so on. We will not enter into those areas. But grievances redressal committee and then representation to the female employees have been put. The another feature they have included into the IR code is a recognition of a negotiating union and a negotiation council. Gujarat, Maharashtra, and Madhya Pradesh, they had a state legislation. They have even as of now, as labor is on a concurrent list, they have tried to address a separate legislation. In Gujarat, it is termed as a Gujarat Industrial Relations Act 1946. Earlier, it was known as a BIR Act, but then the nomenclature is changed in Gujarat as a separate independent state after 1960. Then Gujarat Industrial Relations Act that provides of categories of union based on the membership. The similar kind of thing the lawmakers are trying to put here. That it is always good in an industry if single negotiation agent is there. Instead of you as an employer discussing with the different unions for given settlement or any other dispute, it is always good you have a single negotiation agent. That is a union in instant case. And if it is not there, then the negotiating council, we will see in a slide to follow what does exactly it means for. And once rules will be rolled out, how to constitute those council or to identify the negotiating union. The criteria for recognition of negotiating union has been fixed at 51% or more on a muster roll. I mean, if the union has a strength of membership having more than 50%, whose workers' name have been born on the muster roll, is recognized as the negotiating union. Just the very purpose is to negotiate with a single bargaining agent. And negotiating council, a trade union having support of every 20% of worker. In absence of negotiating union, then the 20% of more workers will get one seat, and those who have less than 20%, they are disregarded. Falgun bhai, the slides have disappeared.
Falgun bhai, if you quickly intervene.
Yeah.
That is why, I had a submission yesterday, Atul bhai, that let me scroll the slides. He said, no, it is good if you give it to me, it will be better. So anyway, just putting in.
Yeah, but I can see. I mean, I can scroll. So not sure about.
I cannot visualize these slides. So what I do is.
Oh, okay.
I need to look. I could not see the slides. Falgun bhai, where are you? Are you on the board?
I am here, sir. We can see the slides. You are not seeing.
I have not done anything. I have not touched any icon here. Now it has come.
Yes, sir.
It's called technology.
Yeah, again it has gone. Anyway, when we are putting in lighter sideways, computer was invented by Sir Charles Babbage, and in his definition he has said it is an idiot box. So the technology, the idiot box, anyway. So the point is, it provides for prepare and adopt the model standing order. That's nothing. It's all as it is have been accepted in the current code. Then to set up the industrial tribunals consisting of judicial member and an administrative member. For certain specified cases, the matters will be decided by the 2-member tribunal, and the remaining shall be decided by a single. Now, what are those matters? Those will be enlisted into the rules. But here I am just trying to bring notice to you all that the labor codes have disappeared from the scenario. Once the formal notification to roll out this code will come, the format of labor code in adjudication as of now, present situation is in case of any collective bargaining of the workers having less than 100 employees will go to the labor courts. Any individual references of retrenchment, termination will be referred to the labor court, and so on, or a recovery into the labor court. Now that has gone, and industrial tribunal has, and also there are no authorities, like in the place of existing multiple adjudicating bodies like Court of Inquiry, Board of Conciliation, and of course Labor Court. I have said short while back. To remove the reference system for adjudication industry, accept reference to the National Industrial Tribunal and Industrial Tribunal that's have been put in practice under the code. The conciliation proceeding shall be deemed to have been commenced from the date of the first meeting. As of now, today, those my friends, those who are dealing with the conciliation and attending the office of Labor Commissionerate might be visualizing that initially for few days, few weeks, primary discussion. Then matter is admitted, and then in case of failure of conciliation, it is referred to the appropriate court. Now, here there was one case here also. And there is one, ATIRA is the organization, Ahmedabad Textile Industrial Research Association, versus its workmen. The matter reached up to the division bench of the High Court. Unfortunately, it is still pending. But the point is where the bone of contents on all this is that law provides for conciliation proceeding should be completed within 2 weeks, for an example. And our citizen charter provides that in 6 months I have to refer the case to the appropriate court. But then, from where one should calculate the conciliation proceeding have commenced? Then this law has, this code has answered that question, shall be deemed to have been commenced on the date of the first meeting. Then, the provision of giving notices of 14 days before strikes or lockout was restricted into the ID Act, current Act, for only public utility services, or the matter which are pending in the conciliation where the workers who want to go on the strikes are concerned or connected with. Now it is generalized for any industrial establishment. One has to give a notice if employer wants to impose the lockout or a temporary shutdown, or workers want to go on the strike. Now the industrial employment standing, the obligation on the part of industrial establishment pertaining to mine, factories and plantation having 300 or more. Now this threshold of present 100 workers where prior permission is required has been raised to 300. That is another significant change is made. So quickly enumerating the changes which made. Now here again I will say that there is interlinking of all the labor codes. Now why I said so, because the factory word has figured out, mines has figured out, and in OSH code, Occupational Safety, Health and Working Condition Code, there is a statutory provision that every employee should be given with the appointment letter. So that is mandatory, and giving the leverage to all the employees who are employed in factories, mines, to which OSH code applies. Must get, so here while talking of this threshold which has been increased to 100 to 300, one should ensure that they have been given the appointment letter and so on. Now this was actually, reskilling of fund for training of retrenched workmen is something kind of, the spirit they have retrieved. I discussion with the, one who was drafting the law. If you all are aware or recollect that Employee State Insurance Act has a provision that if somebody is continuously paying the contribution for continuous 5 years, and if that industry is closed down, and of course outcome of the close down is he or she is retrenched, then he will get salary up to 6 months from his contribution by ESIS. That's the provision is still there in ESIS, but the concept is being retried. That was restricted to only closure. Now this is with reference to any retrenchment. So reskilling fund is the provision. Now modalities of course will be decided into the rules, but the fund shall consist of the contribution of the employer of an amount equal to 15 days of wages, last drawn wages, of course, immediately before the retrenchment, or such other number of days as may be notified by the central fund shall be utilized by crediting 15 days wages last drawn by the workers to his account who is retrenched within 45 days of the retrenchment as may be provided by the rules. So rules will further clarify this. The compounding of offences, again, this is the spirit which government of Gujarat has rolled out in 2015 December have been fully accepted at national level while drafting this code, and that is why the one who is involved in the drafting in lighter part always he used to address me as a Guruji. I'm not talking high of me, I need not do that. If I do that, it's not worth doing that. But the concept is the violation of labor laws are criminal offences, that is all right. But it is not that potential crime, so that it is equated that way. You penalize them, you fine them, see that the whatever offences they were committed are being neutralized. Now compounding word itself, I would like to explain here is, first of all, whatever offence has been committed needs to be neutralized, and then awarded with the penalty whatever is prescribed. That rules will prescribe for which offence how much rupees is to be given. The sum of 50% of the maximum fine provided for such offence is punishable with fine only. In case of where there is a fine, it is, and when the punishment is less than 1 year, imprisonment, a term which is not more than 1 year, and penalty is 75%. A sum of 75% of such offence punishable with imprisonment. Then the whatever penalty is there prescribed, of which 75% amount can be compounded. In case of only penalty, 50% will be compounded. Then there is a penalties of different type for violation or rationalize of such offences. Depends on the gravity of the violation. Then of course the exemption. Now there are few terms which you will not find into these three existing act, that is Trade Union Industrial Disputes Act and Standing Orders Act 1946, which has been included here. I am just trying to explain the core features. The appellate authority, which was not there. Appellate authority is only under the payment of gratuity 1972, which is a part of Social Security Code. But in any legislation related to IR, this terminology has not been there, so this is new inclusion. Of course, employee definition was also not there. Salary they have made, we'll see in the definition, it is 80,000. Here they also included the supervisory and managerial cadre and administrative, and then of course, as we have seen into the wage code, also includes a person declared to be an employee by the appropriate government. In employer also similar thing they have done. Central government and the state government, they have put shoulder on them. In absence of any authority specified, then head of the department of given government setup. And then in case of local body, chief executive officer, contractor, of course, which is already there, or otherwise being a licensed contractor is a separate legal person, and legal representative of a deceased employer also have been put into the definition of employer. Fixed term employer, I have tried to explain in my previous deliberation. that he should be treated at par with the permanent employee in terms of salary, perquisite, etc., who is doing same work or work of a similar nature, and he should be given the all statutory benefits available to a permanent worker proportionately according to the period of services rendered by him. Suppose I am a fixed term employee for 2 years, then you all know that payment of gratuity is applicable to only those who complete continuous 5 years of services. But in case of fixed term employee, it won't be there. If I am for 2 years and if law is attracted by way of strength of employees, I must get the 2 years gratuity on completion of my fixed term. And that's what I have said in the next thing. Then industry, I have tried to define while talking about the salient feature, but does not include owned or managed organizations wholly or substantially engaged in any charitable, social or philanthropic services. As of now, things are different. Because triplet test, Bangalore Water Supply and Severages Board versus Rajappa case is very clear, very simple, that, imagine any activity and which is a part of it, now it won't be there. And any domestic service or any other activity as may be notified by the central government will be out of ambit of the, definition of industry. Then retractment, only few changes they have made. Earlier, the termination of service of worker due to yes, completion, that's 2 double or double B is a different form. It is a fixed term employment. But termination of services of worker on the ground of continued ill health was not treated as a retrenchment. Now it is treated as a won't be treated as a retrenchment. So it's all like that. So union negotiation council, we have tried to see the strike. Only one feature has been added, includes the concerted casual leave. If we all assemble, the total strength is suppose 150% or more go for the mass casual, it is put into the definition of strike. Then one more term has been included into it, that is unorganized sector, which was never there in the either of the IR code. That is, unorganized sector word, when I say, I would like to explain all of you. The lawful definition is, in any unit, if the total strength of workers are 10 or more, then it is termed as organized sector. And any place where the strength of workers is less than 10, it is unorganized worker. And the types of unorganized sector means, if I'm a rake picker, daily wager, vendor, like that, these are as many as 140 activities have been identified by Government of India, where this informal sector has been engaged. And today, if I give the statistics, 93% of the total workforce at national level is in informal sector. So anyway, this they have added into it. Why they have added, I will explain you little later. But then the definition of worker, also they have included working journalist and other newspaper employees, which is defined into the 1955 enactment, and similarly the sales promotion employees also defined under the Self Promotion Condition of Services Act 1976. Then again, but does not include managerial and administrative, who is employed as supervisory cadre and exceeding 18,000. It's not a worker, that's all. It's simply thing. Now grievances redressal committee is mandatory. We have seen that 20 or more employees in which organization they need to have a grievances redressal committee. Works committee was on 100. Here they have tried to reduce that. And the compulsion that make is worker who is aggrieved by the decision of the government committee whose grievances have not been resolved by the state committee within a period 60 days of the decision of that committee to or from that period file an application for the conciliation officer. Now, what I interpret, I discussed with the one who has drafted this. I'm just trying to draw your all, focus here, that it is mandatory for all the workers. In rules it will be more clarified, but what I could gather after discussion with the gentleman who has drafted the act, there may be different literature and material available on the net and wherever. I'm not criticizing them. There are volumes of books on interpretation of subject and law. I'm not touching that area. One who has drafted this and what was in his mind. Just I'm trying to put before you that if you remove me from the job, for an example, I can go to the conciliation officer for retrenchment. However, before that, I must address my issue in the grievances redressal committee, provided that part is attracted. If the strength of employees is less than 20, I can jolly well go to the conciliation office. But if it is more than 20, then constitution of grievances redressal committee is mandatory. And first of all, I must go there, and then I can go to the conciliation officer, that too in the 16 days if my grievances are not redressed. That's what the interpretation has been explained by the one who has drafted the law. Let rules to come may further clarify. Now, somewhere in 2010, the amendment was made that, after the, dispute date, worker has to go to the court within 3 years. In 2015, December, government of Gujarat has reduced to 1 year. Now that will go off in wake of this, or we may put this in rules. I don't know that. Once draft rules we see, we can comment on it. But before the expiry of 2 years from the date of discharge, otherwise one has to approach within time frame of 2 years. Now this is what we have discussed, that negotiating union, the concept has been simply retrieved from the Gujarat Industrial Relation Act, a single bargaining agent, and in absence of having 51%, company has to recognize it. And of course, yesterday I had a discussion with the dealing officer at Labour Commissionerate office. He just sought my viewpoint that how to decide the membership in case of negotiation council. Negotiation agent is very simple to decide. A union that it has a 51% of the work, we will show the membership receipt of the annual subscription, passbook of the nationalized bank that this money has been deposited, and the muster roll, this much members are, that's all right. But in case of 20% or more, one representative, it's difficult to decide. The modality was how to go ahead, that was just discussion, but that I have suggested something and rules will show that. So that's all with a reference to negotiating agent. The time limit to complete the inquiry is of 90 days from the date of suspension. To best of my knowledge, that was not there under the Industrial Employment Standing Order. Now that time limit has been framed. Then conciliation mechanism, I said first, dispute to be raised before the grievances redressal committee, as I said short while back, and then dispute through conciliation offer, it will go to the industrial tribunal. Thus, no more labor courts for adjudication. Then composing of offences I have discussed. So anyway, that's all with reference to what best I can put with reference to IR code. And well, while saying so, I will say Gujarat has over a period of time is enjoying the industrial peace, and IR issues are, in spite of increasing the factories, as many as 43,000 registered factories in Gujarat and 14-15 lakhs around establishment. The labor unrest has been reducing trend. Filing in labor courts and tribunals and even the apex court of the states are less. So, well, we enjoy that mileage of industrial peace, but still then, this is what the, cursory, deliberation of the IR code and wage code. So I once again thank the organization for inviting me and sharing the interpretation in collaboration with one who has drafted the code and so on. So if you have any question, I just will try to address that. Your speaker is off, Atul bhai.
Okay. Yeah, so there is a question on whether manager is eligible for overtime now under this new code. That is a question being asked by Mr. Raghavendra. So that is one question. The next question is on gratuity. What would be the implication of gratuity if employer terminate FTE? I'm sure it is a pro rata which is to be given. You have clarified. And there was a common question by Bharat Jagtap that any gratuity amendment in this code. So these are the three questions which is prominent and pop up. So one by one, if you can take it through.
The manager is whether entitled for the overtime or so. The question is, while reacting to that, I will say that Apex Court has said that who is manager. They have tried to define the manager. Manager means if the manager is having the adequate power to take action against his or her subordinate, if he has a power to sanction or reject the leaves of his or her subordinate, or if he has a power to stop the increment or initiate any inquiry against his or her subordinate, he is the manager. And if you call it the manager, then the manager is not entitled for, a treating at par with the worker.
Okay.
The rest of the designation does not fall within the, ambit of the manager, then they are treated at par with the worker. That's what I quickly interpret. But
okay.
Atul bhai, rules will further elaborate what
absolutely. Absolutely.
Now, the second question, the gentleman who has asked about the gratuity, which I had already tried to explain. If it is a FT system, whatever the period, it may be 1 year, 2 year, 3 year, then proportionate gratuity is to be given where the central provision of gratuity will not be attracted. And third was said, is there any amendment into the payment of gratuity? Yes, there were a couple of print media news that even if I have a 1 year gratuity, I will be entitled for it. But I have close look to the Social Security Code, which also was passed on 28 September 2020. And whatever close study I have, I could not locate what was being in print media displayed. So I will not jump to any conclusion, but quickly in safeguarding my deliberation, I will say I won't come across any amendment as of now.
Correct.
It is par with the existing provision of the Act.
Yeah, so I think somewhere it was a misinterpretation because this was exclusively applicable to the fixed term employees because we are talking about the pro rata benefit. Now the last question from one of my ex-colleague Ruchir, that do we require to get standing order certified in new scenario?
You see, the provisions of the industrial employment standing orders are absolutely retrieved to the same, nothing great, except the changes which I have tried to highlight it. I have just tried to, that's why I said when I begin with, my area of discussion will be what is new in place and how it will be useful or otherwise to the stakeholders. Now, the standing order, certification of standing order is as it is in a present scenario. Either you follow the model standing order or you have your own standing order duly certified by the authority without damaging the model standing order spirit, right? That's how it is.
Correct.
You need
now,
to have
more question.
Yeah, please.
One more question pop up right now is from Chintan Kansara. As per new IR code, standing order will be applicable to which companies? Companies having 100 or more employees? I think it is 300, but you can clarify.
Yes, it will be applicable to 300 or more. You know, there are three situations. In Gujarat, standing order is made applicable to factories employing 10 or more employees. Then if you go into the central sphere, it was 100 or more employees. But in a present code, it is 300 or more employees registered factories. It will not applicable to any hotel employing 100 or more. It is industrial establishment has to be registered under the Factories Act and 300 or more, right?
Correct.
So that's
So I think we have overshooting the time, but let me thank you, Dr. Bakshi sir.
yeah,
That there was really a threadbare, discussion on each proviso of the new code. Very meaningful, very insightful, and very interesting, I would say. Though, I mean, there is a constraint of time, but I would like to take this opportunity to just summarize what we have been, discussed so far. That there was a common definition among the Act. The first time introduction, like a definition of employee in addition to worker, which was prevailing for a long time. Extension of the workers include now sales promotion and working journalist. Definition of the wages, which is very exhaustive now, but clear and very interesting because of that 50% and 50%, 15% provision of, in lieu of the wages and all. Concept of floor wages is one of the prominent feature. Empowerment of the union to file criminal case. Even employee can file the criminal case. That is one of the feature. Compound effect. You have repeated the provision. Yeah. Extend the scope of interstate migrant workers, and interstate migrant worker now includes the employee which are engaged by the company, not only contractor but engaged by the company, drawing less than 18,000 or whatever. So that is a migrant worker. There is a change. Recovery of loss. We can do recovery of the loss for the organization from the bonus amount.
Yes.
Concept of the FT. Now earlier it was for the Gujarat. Now Pan India it is applicable.
Yes.
Change in the standing order proviso. Some of the there are changes. Lesser hierarchy for hearing dispute or adjudication. Now, since labor court is done away, and there are certain, minimization of the hierarchy. Concept of negotiating union and negotiating council. This is a prominent feature, and I'm sure that how our life will be moving ahead. That is a big question. So that is one. Notice of strike. Earlier, it was only applicable to the public utility services. Now it is applicable to private industry also. I'm sure there would be a discipline. Worker reskilling fund you talked about, and the payment of such retrenched worker. That is one of the provision. Role of inspector as an inspector come facilitator. That is of course was prevailing in Gujarat, but now for the country. So I'm sure, I mean, these are the couple of, takeaway from this particular seminar or the program. And definitely it will add some value to the participant who have engaged themselves for the time in the program. But yes, what is next? For the people who are participant and who are HR professional, that is more important. And therefore, I would like to say that aligning our compensation structure basis on the new wage code, that is one requirement. Review of current HR policies and processes basis on these different codes. Review and ensuring better compliance by engaging direct, indirect workforce, because there are changes in the provision now. Reconfigure our current compliance monitoring mechanism or tool, whichever we were having. This tool must be talking about the compliance from the old, legislation point of view. That is to be rectified, and we have to incorporate the changes now. Negotiating and negotiating union and negotiating committee will have its own challenge, but gradually I am sure that it will we will tune to the changes. So this is about I think this is a summary which we can get it from the today's, very meaningful program, discussion, deliberation by you, sir. So I think in a time to come, definitely for HR professional, it is a very challenging time, keeping in mind all this perspective in mind and from compliance point of view. Thank you, Hiren Bhai, in particular, and Society for HR Professional for coordinating the entire program. And I would like to thank very specifically our president, Mr. Ajay Bhatt, who has motivated us to, coordinate or to organize for this kind of the program, since it is a need of the day. So, but yes, at last, we cannot forget our two partners, Crown HR Services and IM Possible, without which, I mean, this program was not possible. It was a very smooth kind of, drive during the program. So thank you very much. And with this, I think let us close the session. Hiren Bhai.
Yeah, thank you very much, sir. Thank you.
Thank you.
Yeah.
Good. Bye.
Thank you, sir.
Bye.
Bye.
Okay. Closing the session now.
Yeah.
Yeah.
Yes, sure. Thank you.
Okay.